Is your motion? Go ahead.
Thank you, Your Honor. Based on the caption of the case, Middleton versus the City of Star, I think it's tempting to think of the rights and legal issues presented as a tale of two cities. But unfortunately, that would leave out probably the most important person or persons that would be affected by the relief that's been sought by the City of Middleton through the Declaratory Judgment Act. And that is the property owners that would be subject to land use regulation and other regulations through the annexation either to the City of Middleton or to the City of Star. The reason why this is especially important in this case is with the backdrop of the 14th Amendment. The 14th Amendment provides to each property owner the right prior to the government making any type of decision that would affect their property rights. It provides that property owner the right to due process. And that is one of the due process issues that was addressed in the Cooper case that the City of Star cited in the initial brief and has been discussed throughout the briefing by Middleton as well. And that case was important, and it was also unique because it addressed a county zoning decision that took place just prior to the passage of LUPA. And so the Idaho Supreme Court had an opportunity in that Cooper decision to set a baseline essentially for what state law is going to have to provide in order to meet the constitutional due process rights that every property owner would be entitled to. So whatever Idaho law is, it's going to have to be at least meeting the baseline of what the 14th Amendment requires. And that's why Cooper was such an excellent opportunity to understand how the Idaho Supreme Court would handle those issues. And certainly Cooper has continued to be cited by the Idaho Supreme Court. So despite the characterization that it was provided in the City of Middleton's response brief, it certainly has not been overruled in the way the Idaho Supreme Court treats Cooper. And it wouldn't make sense to read Giltner 1 or 2 that way. Giltner 1 was decided in 2008. It wouldn't make sense to read that case that way because that was the way the parties presented that case to the court. It was an issue of construing state law. And so if the only issue before the court in Giltner were state law interpretation issues, well, the underlying message and principles of constitutional law that were addressed by the Idaho Supreme Court in Cooper are alive and well and would help guide the court's framework of conceptualizing what the remedy is that Middleton has asked for. Middleton, in asking for the remedy they've sought, they've really changed the nature of what is being designated through the area of city impact. That process is set forth in LUPA under Idaho Code 676526. And if you look at the procedure, which is there, it's pretty complicated, but there is a procedure for how to go about both creating an area of city impact and also how to resolve disputes. But if you look throughout that procedure, at no point in state law is there an opportunity for a property owner who's affected, who's within that area of city impact, to present any type of due process or even assert that there was an error of law in the process of coming to that decision to an Idaho court. And that was addressed by the Student Loan Fund of Idaho case versus Payette County. And so if the Idaho Supreme Court does not view an area of city impact as having automatically any type of restriction on property rights, it therefore has not required that courts provide that due process opportunity to a property owner to contest when the designation is made. And so that is no matter what, no matter how entitled Middleton might feel that designation gives them and the language they've used of having been invaded by the City of Star, it is not the equivalent of a zoning decision. The Declaratory Judgment Act certainly is available as a remedy in theory, but not necessarily in this case. And I think that the case law that has been cited supports that. It is available in a very limited fashion when, in particular, when it is being used to address a legislative decision as opposed to a quasi-judicial decision. And a legislative decision is not going to be set aside unless there's a clear showing, and therefore there would need to be a clear assertion in the pleadings that the action taken is I'm not going to pronounce that right, confiscatory, arbitrary, unreasonable, or capricious. And that language is from the Burke case that was cited in the brief. And the reason why that is important is because it's really a balance of powers between the judiciary and legislative power, first that's held by the Idaho legislature, as well as when local governments are exercising their legislative authority. And so in looking at what has been asserted as the action that would have to be arbitrary, unreasonable, capricious, well, what STAR has done is it has followed the law. And prior to the judicial review remedy that was set forth in 5222, there were a lot of decisions that were put before the court, annexation decisions that were handled by the Declaratory Judgment Act. But if you look at each of the decisions, which were, they were all cited in the City of Middleton's brief, specifically the Hendricks case made reference to those decisions. Those are all specific decisions. They're a declaratory judgment about specific facts, and they're not a prospective restraint on a city's legislative authority. And it also gave the reviewing court an opportunity to assess things such as standing. And it also gave, and in each of those cases, almost all of them, the person bringing the Declaratory Judgment Act was the property owner themselves. And so it gave an opportunity for the property owner who was affected to be involved in that process and making a determination of the laws and rights that were assigned through the remedy. That is not the case in this action. There are innumerable individuals that would have to be identified and included in order to provide adequate due process to all those who would be affected. Now that judicial review has been expressly authorized, the reason why I cited the second Giltner case, the Giltner 2 decision that was made in 2011, is because it provides an example of this is how the Idaho Supreme Court is going to address a more generalized authorization to bring an action versus a specific authorization for a remedy. And there is an available remedy under 5222 now. And very importantly, that remedy provides the due process that is required to protect the property owner's rights prior to any negative effect that it would have on their property. And it just doesn't make sense if you think about the area of city impact, especially in light of the Student Loan Fund of Idaho versus Payette case. It does not make sense to give the area of city impact designation a higher weight than the property owner's rights themselves. That is just contrary to all of the cases that address due process in within the development of Idaho land use case law. Moving on to the standing issue. Comprehensive planning itself is not an injury. And if it were, if all the city had to do was engage in comprehensive planning through LUPA in order to be able to say later, well, this is our injury and we'd like to have a say in what this property owner outside our jurisdiction is doing with their property, well, it would serve to invalidate a whole line of cases that characterize comprehensive planning only as a legislative function. The most important of those is the Evans versus Teton County case, which states that a comprehensive plan is not a legally controlling zoning law. It serves as a guide to local government agency charged with making zoning decisions. And so regardless of how much time or expense Middleton has chosen to exert in their comprehensive planning, that is something that is voluntary, and it is an exercise of their legislative function. And certainly if you look at the cases that have uniformly stated that a property owner who is specifically affected by a comprehensive plan, a generally applicable legislative document, well, they're not allowed after the fact, after they see the comprehensive plan that has been approved by the local government, they're not allowed then to come to court and contest the legality of that process because it's a legislative decision. So if
Ms.
the court,
Nielsen, it
yes,
feels like a lot of your argument goes to the merits of the case and not to the issue of whether or not the court has jurisdiction or if the parties have standing. I see that the city of Middleton is alleging that under the annexation statutes and LUPA that they do have some rights, and they're seeking interpretation from the court. And if the court interprets that law in their favor, then it seems that they have alleged that they're having some injury if the law is interpreted in their favor. Aren't they entitled to have the statutes construed by the court under a declaratory judgment action?
Your Honor, I think that part of that is correct. And the part that is correct is they do have an opportunity, and they do have that opportunity once, if they are challenging a specific annexation through the judicial review process, they have that opportunity. And then the court has the benefit of an actual justiciable case. So this is a matter of standing, and it's not going to the merits. And it's just as much an issue of standing in that Middleton must be able to prove in this case as any other property owner or litigant would have to prove in any of the other land use cases. And so they can't skip over that simply because they're looking to create a remedy prospectively, because if they do, then the court is making a decision based on only their assertion of due process, and is skipping over the innumerable individuals that would be affected if the court were to grant the relief. And so that's the reason why it's been brought as a motion to dismiss, because if this is something where the pleadings could be altered in order to have an actual justiciable case as opposed to a broad restriction of legislative power, then that should be done from the outset of the case. But the way it's asserted as it currently stands, it is very broad, and it would infringe on the due process rights of those who are not included. And so as far as being able to show an injury, it is a matter of law that the comprehensive planning that they've asserted to be that injury could not constitute an injury under the law, because that is a legislative power. The type of standing issues that the court has addressed before for a property owner, for instance, is looking at a parcel and asking themselves, okay, this parcel was now subject to a rezone. And then they look at perhaps the neighboring parcel, and then they would ask, well, is this neighboring parcel going to be affected by the rezone of their neighbor? And then they would look at things like noise, smell, and they would make that assessment. And so that standing issue is something that absolutely goes to the jurisdiction and is a 12B1 matter. And it is something that the city of Middleton, because of the type of relief they've sought through the Declaratory Judgment Act, it makes it difficult to impossible to determine. But trying to conceive of, well, what would be potentially something that they could assert? Well, if there had been a sewer line that had gone all the way up to a property that was later annexed by the city of Star, well, that's something that if they had asserted it, it's not going to the merits, it's just, have you asserted something that could be considered an injury? And comprehensive planning is the only thing that they've asserted. And that cannot be an injury, because if it were an injury, or if that is the only thing that a city has to do in order to be able to then at a later time restrict the property rights of the property owner, then it would change the effect of many cases in Idaho land use case law, such as the Student Loan Fund of Idaho versus Piatt County case, where a property owner specifically asked the Idaho Supreme Court to address an area of city impact designation where they were within that area of city impact. And the Idaho Supreme Court said, I'm sorry, that area of city impact designation is not itself standing. It's a legislative determination, and simply by being designated as being within an area of city impact, your property rights are not going to be restricted. And so if that is true, then at what point would a property owner within who would be affected within this area of city impact by Middleton, at what point could that person have raised the issue to Idaho courts that their property rights were about to be restricted? There's the lack of assertions is absolutely not going to the merits. It's about the pleadings. And if there has been a specific injury, they should absolutely include that in the pleadings so that the court can assess whether or not they have demonstrated through the assertions that standing that is required and is absolutely a matter for the court's jurisdiction under 12b1. Middleton hasn't asserted an action that this court could possibly fashion in a way that could be also read under Idaho law to be constitutional, because the remedy they've sought in and of itself would restrict the property rights in a way that would render that all the Idaho cases that were cited, it would render so much of that Idaho case law invalid. And in the end, you have to go back to Cooper and the 14th Amendment of the Constitution, because however we read LUPA, however we read the annexation statute in Title 50, it has to be constitutional. And so there's really no way to get to the remedy they've sought without violating the constitutional rights of the property owners, because at no point prior to now would they have had an opportunity, or prior to a future annexation application, at no point would they have an opportunity to assert their rights, which is why judicial review, which is provided in the statute 5222, that is the authorization from the legislature. That is them providing the process that protects everyone's rights. And it's certainly something that Middleton is free to bring, and their arguments would be assessed at the time of the annexation, where the property owner would also have an opportunity to participate at that time. Thank you.
Thank you. Mr. Meyer, a couple of questions I have is, why does the court have subject matter jurisdiction on this, and why does the city of Middleton have standing?
Thank you, Your Honor. May it please the court, I am Chris Meyer here on behalf of the city of Middleton, and with me on Zoom is the city attorney Mark Hilty and my partner Melody McQuaid. Your Honor, you summed up the two issues that are before the court, and I will address them in turn. The first is the argument made by Starr that the annexation statute does not authorize judicial review of Category A annexations. At least I think that's their argument. I'm frankly perplexed by Ms. Nielsen's suggestion that she makes during the oral argument just now that we ought to be bringing this as a judicial review. That's a real head scratcher for me. Judicial review is not an available option in a Category A annexation. I should think there would be no dispute about that. And
I do have a question about whether or not this is actually a Category A annexation. Are all of the requirements for Category A met? Because I see 3 requirements.
Your Honor, we're not speaking about some past annexation. I think to answer your question about past annexations, yes, they were all Category A annexations in which the requirements were met, but the issue before this court is future Category A annexations, and they are being teed up as we speak. And the question is, if the city of Star were to engage in a category annexation, is it lawful or unlawful? Given the fact that this lawsuit is about category A annexations, it is indisputable that judicial review is not available because the legislature has made judicial review available only for category B and category C annexations. It isn't hard to be a category A annexation. Basically,
as I read
voluntary.
the category A requirements, it seems that the city of Middleton has alleged that these annexations that occur were not even within STAR's comprehensive plan. Is that correct?
I believe that is correct in the sense that the STAR's comprehensive plan does not reach into Canyon County, but that might be a defect in the annexation, but it doesn't make it not a category A annexation. And the category A annexation is a voluntary annexation, and that's what we're dealing with here. If there's some defect in it, then it could be overturned, but only through a declaratory action. I don't make the rules, the legislature makes the rules, and the legislature has been crystal clear that if it's a voluntary annexation, there is no judicial review. I'll continue unless the court has
No, go ahead.
to
Go ahead.
explore that further. You know, STAR's suggestion that the absence of judicial review for a category A annexation leads to an absurd result because what that would do is it would say that all category A annexations are basically immune from any sort of judicial scrutiny. Cities can undertake them with impunity, without regard to compliance with any of the statutory requirements, whether substantive or procedural. I mean, in theory, a city in Ada County or Canyon County could annex land in Pocatello, notwithstanding the fact that that is not adjacent to the city that was doing the annexing, and if one could not bring a declaratory action to challenge that, there would be no way of challenging it. So I mean, that is, I think, a crazy idea, but it is the logical extension of what the city of Star is suggesting here, and it's ironic as well to hear the city of Star raise the questions of due process by suggesting that we should not be able to bring a declaratory action to address such violations. The whole point of allowing these declaratory actions is to allow due process for either the city of Middleton or any landowner that thought it appropriate to intervene in this or any other annexation matter. And that's the only way that a category A annexation can be characterized. Now, to be fair, I mean, the Star is correct that judicial review is precluded. At least I think that's their argument. Is precluded for category A annexations, but declaratory actions are available, and these are two entirely different animals. A judicial review, as the court well knows, is an appellate type of proceeding based on an existing record. The parties are petitioners and respondents, and it's backward looking at an action taken by a municipal entity or a state agency, whereas a declaratory action is a civil action. Plaintiffs are plaintiffs and defendants. It's an original action without an underlying record, and it can be either forward looking or backward looking. So, I mean, when Starr says, well, the unavailability of judicial review precludes this action is scrambling eggs. They've raised issues that are basically going to the merits, and they've raised issues having to do with judicial review that don't bear on whether a declaratory action is available. When I say scrambling eggs, I didn't make that up. That is what I learned from my favorite law school professor many years ago, Hart Wright, who would always admonish his students, don't scramble your eggs, by which he meant, don't take legalist standards that apply in one context and apply them to a context where they don't belong, which is what Starr has done throughout this proceeding. And Your Honor called that into question as well in your colloquy with Ms. Nielsen, where you suggested correctly that she is raising issues that really go to the merits and don't go to the question of whether this case should be dismissed on a motion to dismiss. Now, Middleton devoted many pages of its brief to demonstrating how a DEC action remains available to litigants, notwithstanding the unavailability of judicial review. There were, in case after case, Middleton identified authority to that effect. And it's true for annexation cases, it's true broadly in all sorts of land use cases, and it's true in all sorts of cases not even having to do with land use. It is a general principle that declaratory action is available notwithstanding and often because of the unavailability of judicial review. Starr never responds to that. And instead, they say, oh, the Hendricks case, they sweep it aside, even though it expressly says that judicial review is available. And they say, oh, that's because that's a 1969 case. And it and all the cases it relied on were prior to 2002, when the legislature amended the annexation statute to authorize judicial review for categories B and C, which this is not. But the fact is, judicial review has never been available for Category A. It wasn't available before 2002. It's not available today. So nothing has changed. The precedent of Hendricks that the declaratory actions are available remains good law. Moreover, Starr simply ignores the post-2002 cases, which continue to acknowledge the availability of the availability of a declaratory action, notwithstanding the preclusion of judicial review. Notably, the Highlands case, 2008, where the court said, quote, the dissent also argues that this opinion will prevent property owners from obtaining judicial review of decisions downzoning their property. It will not. As we recognized in McCuskey, such landowners can seek relief in an independent action, end quote. And in the Giltner 2 case that Ms. Nielsen spoke of, the court said just the opposite of what Starr is arguing. They said, and I quote, it appears that Giltner jumped on the wrong horse to obtain judicial review. Rather than trying to obtain judicial review under a statutory provision that did not really fit, Giltner could have sought relief in a declaratory judgment action. Now, our table of authorities runs 3 pages, and Starr's never effectively responded to the innumerable cases upholding the right of Middleton to engage in this declaratory action. Instead, on reply, it comes up with a case that had not been discussed previously, this Student Loan Fund of Idaho versus Payette County, which Ms. Nielsen discussed at some length in her opening argument. That case runs directly counter to both the issue of whether a DEC action is appropriate and also for standing. As for whether a DEC action is available, that was a DEC action. And the court never questioned whether it was a DEC action. To the contrary, the court in the student loan case said, and I quote, the fund's action is for declaratory relief. Idaho's courts are authorized to determine by declaratory judgment the validity of contracts and municipal ordinances and the rights and status of persons thereunder. So that was a case where the court said a deck action was appropriate. Where the plaintiff stumbled in that case was on standing, and I'll get to that in a moment. So I don't want to scramble my eggs here, since we're talking about the deck action first. But we need to get there momentarily. And suffice it to say for now that the case does not help the city of Star. The Star then pivots in its, as it continues its reply brief, to an argument about the Category A exception. And this argument, again, it raises egg scrambling to a whole new level, because that's an argument on the merits that doesn't go to jurisdiction. Now let's take it step by step. What is the Category A exception? It is an exception to the requirement that a city may only annex land within its own ACI. Everybody agrees on that. Where we disagree is whether it goes beyond that to authorize cities to annex land in some other city's ACI. That's the whole question presented in this case on the merits. The Star says, and it's frankly difficult for me to understand their arguments, I will quote from their reply brief. Star says, quote, if the Category A exception is not applicable, we don't really say it's not applicable, we just say it should be narrowly construed. But Star says if the Category A annexation is not applicable, as Middleton has asserted, then Middleton could and should challenge those specific allegations by filing a petition for judicial review. This argument makes no sense. A narrow interpretation of the Category A exception, a substantive question, doesn't have any effect on the court's jurisdiction. It remains, so long as it was a voluntary annexation, and as the court points out, meets other requirements of the Category A provision, it is a Category A annexation, whether the Category A annexation is broad or narrow. And consequently, judicial review is unavailable. Why Star continues to say we should bring this as a judicial review, I just frankly cannot fathom. Now, because judicial review is unavailable, that is one of two reasons that Middleton did not bring this case as a judicial review. The other is we are not challenging past annexations, which is what you do in a judicial review. Rather, we are saying enough is enough. Your Honor, please instruct Star that it may not do this anymore. It may not undertake any new unlawful Category A annexations. You can't do that in the judicial review. You can only do that in a deck action. Now, Star also says that in its reply brief, I think for the first time, they make the allegation or the argument that deck actions can only be backwards looking. They offer no authority for this, and frankly, it is just wrong. There are four of the deck action cases listed in the brief submitted by Middleton are forward-looking deck actions. They can go either forward or back. The four forward-looking deck actions are Wasden 1, Wasden 2, Linganau versus Lumpkin, and Crane Creek. They can go either way. Those are just the four of the ones that we identified. There are countless others that are out there. Indeed, the whole concept of declaratory relief was envisioned from the outset as primarily providing forward-looking relief. It can provide backward-looking relief too, but its main purpose was forward-looking relief. I quote from Wright and Miller. In adopting the Declaratory Judgment Act, it was Congress's intent to prevent avoidable damages from being incurred by a person who is not certain of his rights, to afford that person an early adjudication of his rights without waiting until his adversary sees fit to begin suit, which usually will be after damages have accrued. That's the situation that we have here. We don't want to sit back and wait until Starr does it again and Middleton suffers more injury. We want to have the question resolved today. And some Starr's argument about the unavailability of judicial review just has no basis. Let me turn now to standing, Your Honor. The Starr alleges that Middleton has failed to allege sufficient injury to satisfy the case or controversy requirement under Article 3 of the federal Constitution. Now, in analyzing this question, it's important to remember where we are. This is a motion to dismiss. In a motion to dismiss, the court looks only to the adequacy of the complaint's allegations. For purposes of a motion such as this, those allegations are accepted as true. Indeed, Middleton has not contested the truth of Starr has not contested the truth of Middleton's allegations. It has submitted no affidavits or other evidence casting doubt on Middleton's allegations. Thus, the court need not and must not look beyond the four corners of the complaint to resolve the question of Middleton's standing. The question is simple. Has Middleton described an injury within the meaning of the law of standing? The answer is yes. As the complaint alleges, Middleton will be injured by Starr's illegal annexations because Middleton has engaged in planning. We've heard counsel for Starr acknowledge that, yes, there's been some planning, but it isn't just planning, here's a piece of paper and I'll put it on the shelf. It's planning and has made investments and has made zoning decisions and approved developments on the basis of its ACI, so that ultimately actions that take place within the city of Starr will dovetail appropriately with land that ultimately will be annexed in the ACI. Now, this is not just, I would characterize it this way. They would say, it would be nice to have more taxpayers. Wouldn't that be nice? That is not what this case is about, Your Honor. This case is about planning and investing in infrastructure within the city of Starr. Now, within the city of Middleton, excuse me. I'm frequently dyslexic on these things. Middleton isn't just making up this injury. This is at the core of its obligations under LUPA and the annexation statute. The very first sentence of the annexation statute says that it was designed for these reasons, quote, to assure the orderly development of Idaho's cities, to enable the orderly development of private lands, and to equitably allocate the costs of public services in management of development on the urban fringe. Similarly, the Idaho Supreme Court has said, and I quote, the object of this requirement, referring to establishing ACIs, was to delineate areas of future contiguous growth in order to assure their orderly development and thereby reconcile potentially competing designs for boundary expansion with accepted land use planning principles. That's what we have going on here. The city of Starr is invading. It has invaded and plans to have further invasions into this ACI that completely undermines the very things that the Idaho legislature told Middleton to do. The Middleton's complaint, 18
Meyer,
pages long.
If I understand your allegations, you're claiming that this encroachment into Middleton's ACI is contrary to the statutes, and that's why you're seeking an interpretation to clarify that is a violation of the statute. Am I understanding that correct?
That is correct. That is correct, Your Honor.
All right, thank you.
And to be clear, the things that the injury that is suffered by the city of Middleton is not just disappointment in its hope to annex something. It has taken decisions, and the city of Starr says, oh well, you didn't point to anything more specific. Well, there isn't a requirement to point to something more specific. I mean, if somebody files a complaint and says the plaintiff suffered bodily injury when the defendant ran over him with his car, you don't say, oh, well, throw him out on standing grounds because he didn't say whether he broke his arm or he broke his leg. And why is that? Because we have notice pleading, and we have alleged we have allegations that specifically say investments have been made, decisions have been made in reliance on this. And here's what the United States Supreme Court has to say about this. I'm quoting from the Lujan versus Defenders of Wildlife case. At the pleading stage, that's where we are, at the pleading stage, general factual allegations of injury resulting from the defendant's conduct may suffice. For on a motion to dismiss, we presume that general allegations, listen, general allegations embrace those specific facts that are necessary to support the claim. Well, Middleton clearly has made general allegations that are sufficient to put everyone on notice as to what the darn problem is. And unless those allegations are called into question through countervailing evidence, that suffices at this stage of the proceeding. Let me turn now to the student loan fund versus Payette County case. That was the case I mentioned earlier, and I said I'll come back to it in the context of standing. That case really goes to the point of what we have here. It all turns on the adequacy of the plaintiff's allegations. And they don't have to be very specific, but you have to allege injury. In the student loan fund case, what really happened, and I assure you it is contrary to the description that was provided by counsel for Starr just a little while ago. The student loan case had nothing to do with legislative versus quasi-judicial, that distinction. Rather, it turned on a standing question, and it said that there was an insufficient allegation of standing. This was a case where there was a landowner, the student loan fund, owned farmland. And the Payette County adopted an ACI that said that farmland is now going to be farmland, still going to be farmland. They called it, the court said, oh, they gave it a new label. They called it agricultural preserve. It was the same thing under the zoning before. And here's the problem, that the plaintiff in that case failed to allege that it had any plan whatsoever to develop the property. The court said, if you would have alleged that, you would have had standing, but you didn't. The court said, and I quote, the deficiency in the fund status is not that its injury is undifferentiated from that suffered by the general populace of Payette County, but rather it has shown no injury at all. And the court was very explicit on this. They said, you never said you were going to develop it, and we have no reason to think you're going to develop it. If you ever think you're going to develop it, come on back. We will dismiss without prejudice. But right now, you haven't been injured. So that case completely undermines the argument pressed by the city of Starr now, which because this case says all you have to do is make an allegation. You have to make the critical allegation. We have an 18-page complaint that more than adequately alleges. I mean, I hesitate to take the court's time reading those allegations. We identified them at the tail end, but complaint paragraphs 14, 15, and 16 are quite explicit in this. And certainly the city of Middleton could provide additional specific. We could tell you whether we broke an arm or a leg. We could tell you about sewer lines. We could tell you all those things, but that's not required at the pleading stage in a motion to dismiss for basis of standing. What is required? Well, what's required is that you show that there be a potential injury. And the courts are crystal clear. There doesn't need to be an actual injury, just any potential injury, so long as it's not purely speculative. Well, in a situation where Starr has already undertaken annexations that we believe to be illegal and is engaged in exploring further ones, and it has refused the city of Middleton's entreaty to stop doing so. That's not speculative. And it's not in the, another requirement is it particularized? Well, yes, it's particularized. I mean, even in the student loan fund case, they said, no, it's particular. You're just like a whole lot of other people in that ACI, but you just have to allege that you wanted to develop that land. And you didn't do it. Here, it's even more particularized because the city of Middleton is the only city that has created Middleton's ACI. And it is the only city that the city of Star whose ACI is being invaded. So it is as particularized as one can get. And then causation and prevention are the other requirements, and those are amply demonstrated in the complaint. Now, the Star also makes a comment about, well, the city of Middleton lacks police power outside of its city limits. That is certainly true, and that's the Blaha case. And there's no doubt about that, and it's completely irrelevant because our standing is not based on our desire to enforce zoning requirements outside of the city limits. The standing is based on actions that take place within the city limits under the control of the city of Middleton, where it is making zoning decisions. It is approving or disapproving developments based on zoning within the city, which then will dovetail with its ultimate annexation outside of the city. So that argument, I don't think, gets the city of Star anywhere. Now, I will conclude with this issue that was raised so prominently by the city of Star, both in its reply brief and at oral argument, that the land developers somehow have a right to be annexed. Well, this is more egg scrambling for sure. As the court pointed out, that's a question that goes to the merits, but it is also just fundamentally wrong. And it's important that the court not be distracted by this red herring that the city of Star has now laid across the trail. Now, how do we know that there's no right to annex or to be annexed? Well, the Supreme Court has told us that. In the city of Garden City versus city of Boise, the court said, quote, Garden City has no inherent right of its own to annex property, end quote. In the Hendricks case, the court said, municipalities thus may exercise annexation power only under the conditions, restrictions, and limitations imposed by the legislature. The statutory procedures must be followed, and the substantive elements must be satisfied to effect a valid annexation. If the essentials of the statute are lacking, the annexation ordinance is invalid. There is simply no such thing as a right to be annexed. It is contradicted by the first sentence of the annexation statute that doesn't say, oh, and we're creating rights and property owners. It says that the purpose is to assure the orderly development of Idaho cities. Well, what we have right now is the unorderly development of Idaho cities as a result of Star's illegal actions. So, but this is a digression, Your Honor. As you suggested in your colloquy, it doesn't have anything to do with the merits of the case. So let me conclude by reciting the admonition that has been made so often by our Idaho courts that motions to dismiss are disfavored. They are disfavored for good reason, because they have a tendency to waste the court's time and the party's money, such as the case here. Star has offered no authority for its contention that declaratory action is unavailable to Middleton, and it is engaged in a facial challenge to Middleton's standing, despite the fact that Middleton has more than amply pled allegations that support standing. The motion should be denied, and the case should move promptly to the merits. That concludes my prepared remarks. I'll stand for questions if there are any.
No, thank you, Mr. Meyer. Ms. Nielsen, we've used a lot of time here, having several other things coming up. I'll give you 5 minutes to respond. You're mute still.
Thank you, Your Honor. I'll do my best to move quickly. Under the question that's raised is whether or not there is a necessity to even clarify the law with this case. And it's been raised that the Category A exception, which comes from the interpretation of both 50-222 and 676526 of Idaho Code. So if you go to 676526, it says, subject to the provisions of Section 50-222 Idaho Code, an area of city impact must be established before a city may annex adjacent territory. So the Category A exception isn't just about whether or not there's judicial review. It's also about whether or not a city can annex prior to first establishing an area of city impact. Those two things go together. And so looking at the Category A annexation statute, you can read under paren 3A1 of 50-222, all private land that Category A annexations are, all private landowners have consented to annexation. Annexation where all landowners have consented may extend beyond the city area of impact, provided that the land is contiguous to the city and that the comprehensive plan includes the area of annexation. Now, the city of Middleton has not raised any issue in its assertions that would question whether, and in fact, they do agree that this is a Category A annexation. And yes, that would mean that judicial review isn't available, which is why if Middleton had raised a judicial review case, what the court would do is what they did in Henry City of Shelley, which is the first thing they would determine is whether or not it's a valid Category A annexation, because there was an issue in Henry City of Shelley of whether or not it was a Category A annexation. And so they made that determination.
Can you have a valid Category A annexation if it's outside of the comprehensive plan of the city that's annexing?
Outside of
They see that as a third requirement for a Category A.
Correct. Usually the annexation, this isn't something that City of Middleton has raised with these facts, but the comprehensive plan is usually amended to include the incorporated area as part of that process. So that's automatically a part of that annexation process typically. But if that were the case, that would certainly be something to raise, and a party could do that through the judicial review process in raising whether or not this was a valid Category A exception and receive that review through that process. Or they could do a declaratory judgment act, which is available, but it's in limited circumstances. And that's why it's important to consider that this is a declaratory judgment act for a legislative act, not a quasi-judicial act, but it is available. And so if you look at, and this is also, I would say, it's not about whether or not there's been general allegations in this case over injury. Because certainly you can always make general allegations and claim that there's injury, but there's obviously something more that's needed to establish standing through injury, and that is a requirement. And if you look at the City of Middleton's response brief from page 37 to 38, if you go through each of those paragraphs, what they are alleging is that generally they engaged in comprehensive planning. They haven't, and there is no Idaho case that they've provided that establishes that comprehensive planning, a city's voluntary decision to do that, is an injury. That's not an injury. The types of cases that have been cited by both parties clearly establish that it has to be something else to establish an injury, and that requires looking at a specific annexation. I'd like to address the City of Middleton's contention that they have provided 4 cases that demonstrate that a declaratory judgment act can be used for prospective action. The first 2 and the two that were the Wasden cases, well, that's an attorney general. That's a completely different situation because the attorney general has provided jurisdiction that is very different than a standing question in a private declaratory judgment act. It's just you're comparing apples and oranges there. If you're comparing the city of Middleton's ability to bring a declaratory judgment act for property outside of its jurisdiction to whether or not the attorney general can bring something that under Idaho code, they've been expressly provided the authority to bring. Same thing with the Crane Creek case. If you that case, looking at it, it's a tax commission case, and it has to do with whether or not the taxpayer had been required to exhaust the procedures prior to the declaratory judgment act being filed. But it's not a land use case. It's not any way analogous to this type of situation. The land use cases look at the parcel in question that is going to be affected. And at this point, the city of Middleton has not brought this declaratory judgment act to the two prior annexations that it alleges are unlawful. Because if they had, then we would be able to do that assessment of injury and standing to those two specific annexations. Rather, they have shifted the focus into the future indefinitely. And so there are innumerable and indefinite amount persons who would be affected based on the pleadings that they've crafted. And it does not if the court, even assuming they're able to prove everything they've asserted, if the court were to grant the relief requested, it would render 6526, the area of city impact statute, unconstitutional. Because in order to read that constitutionally, it has to be read that the area of city impact designation will not negatively impact a property owner's rights. It is their right to apply for annexation to a contiguous city under 50-222. It's express. There's no clarification of law that is necessary, and the relief and granting the relief would render a different impact to the area of city impact designation that would not protect the due process rights of the property owners affected. Thank you, Your Honor.
Thank you. Appreciate the arguments. This matter was very well briefed by the parties. I'll take this under advisement and get a decision out as soon as we can. Thank you.
Thank you.
And you may be excused if you'd like.
Thank you.
So the next matter I have on my calendar, I think may have already been resolved, at least on this motion, Armenta et al. Versus Jose Perez et al. We have counsel for that in that case on the line. I believe we had a stipulation that may have resolved all that. I'm hearing nothing, so move on to the next matter. We have our Spanish-speaking interpreter on the line, so I'm going to take